Good afternoon, everyone. Thank you. It's fabulous to see you all, and welcome to the 2019 Edward J. Ross Lecture in Litigation. For those of you who don't know, I'm the Dean of the Law School, Gregory Mandel, and I'm especially thrilled to see so many of you here today. As the faculty and staff and students at the law school know, this is one of the busiest times of years in a law school's semester or academic year. And so I really appreciate each of you taking some time out of your day-to-day to come and join us for what I know will be a remarkable lecture. I would like to take a moment to extend a special thanks to Helene, Edward Ross's wife, and to all of the Ross family members who were able to join us here today. Ed's record, Ed's history as a tireless advocate for those in need of justice endures in your hearts, in the hearts of all of those who knew him, and in the many lives of those who he touched and who he affected. We are grateful for the opportunity to keep that legacy alive, to keep that memory alive, and thank you all for joining us in that today. The Ross Lecture in Litigation is one of those moments each year at the law school where we take a moment to reflect upon who we are and what it is that we do. Ed Ross was a champion for justice. He was an advocate in every sense of that word. He brought passion and integrity and excellence to everything we did. We've had the privilege through this lecture over the years of hearing from a number of speakers whose own work has been driven by those same ideals. Lawyers who are among the very best at what they do. From her work leading the Michigan Innocence Project to her appointment as Chief Justice of the Michigan Supreme Court, the Honorable Bridget Mary McCormack is one such advocate. And because I'm sure you are much more interested in hearing what she has to say than what I have to say, I'm going to quickly turn the podium over to my colleague, our Director of Advocacy Programs, and let Jules Epstein introduce the program and get us underway. Thank you, Jules.
So, good morning, and I apologize for my throat. So, here we go. Selected by her court to be Chief Justice, an international scholar on forensic science, a member of the National Commission on Forensic Science until it got put out of business, co-founded the Michigan Innocence Project Clinical Law Dean. So how do you introduce Bridget McCormack? Well, I'm not going to. What I'm going to do instead is let her peers introduce her and let the words of some of her opinions introduce her. Let me start with a name many of you know, Barry Scheck of the Innocence Project. I learned something from him. He met Bridget when she was a law student in 1991, working on a battered woman's defense case, where when the client fell apart, it wasn't the lawyers who could help. It was Bridget who took over. Ended up in an acquittal and the beginning of a remarkable career. Barry wrote, Bridget was a precocious law student, even among the NYU crowd, a terrific fighter as a legal aid lawyer. She's the best of us. Our co-author, Professor Itiel Dror, the leading cognitive, or one of the leading cognitive psychology researchers in the world, who writes about the intersection of psychology and forensics, wrote, the NAS report is just a report, meaningless without the foot soldiers at the trenches leading the actual everyday battle in administering fair justice. Bridget McCormack is the model, the par excellence example of someone making a difference. Our colleague, Michael Reisinger, a scholar in evidence law, forensics, wrongful conviction. Bridget is a fine legal mind combined with heart. Our friend John Holloway at Penn Law School, head of the Quattrone Center. She has an effortless way of conveying personal care for the people she works with, the clients she served, and now the individuals whose cases she reviews. And the Justice's colleague on the National Commission on Forensic Science, Federal Judge Jed Rakoff. On the National Commission on Forensic Science, she was the epitome of balance, thoughtfulness, and judiciousness. No wonder the commission was terminated. So what else can I tell you? If you go into Lexis or Westlaw, you will find 68 opinions, majority concurring, occasionally dissenting. I don't know how that's possible, of Bridget McCormack on the Michigan Supreme Court. She's written about sentencing guidelines and whether the sentencing guidelines deprive people of a fundamental right, the right to trial by jury. She upheld the right of local school districts to ban weapons from schools. That when police come to your home at 3 a.m, it's not a knock and announce, it's a search. She's written about juvenile lifers, about the failures of lawyers when they don't test science by getting experts. And a quote that's now my favorite. When she wrote about the job of a judge in deciding whether an error made a difference, we call that harmlessness. She wrote, "Of the many judgments I must make in this job, harmlessness is among the hardest and most humbling." That's a remarkable person. Will you join me in greeting Justice McCormack?
Thank you very much. Give me 1 minute to make sure nothing, I know what I'm doing here. I'm going to move that, right? Because you can all hear me. I'm mic'd. I'm good? Good. I don't usually use PowerPoints, but there are a couple things I wanted you to see. So I have a PowerPoint and my notes, and I'm going to make sure I know what I'm doing here. I really appreciate that generous introduction. I taught my kids that low expectations are the key to life, and so they really are. So I hate those introductions. I mean, but it was lovely, and I appreciate it, Jules. Just makes me feel like I should say, thank you very much. I'm going to go now. I am honored to be invited to give this lecture, and really honored that this, and impressed that this school holds this lecture. I would like to thank the Ross family for continuing it. I think it's a fantastic tradition, and it's incredible to me to see so many people from the community show up. I have a very close relationship with another law school, the University of Michigan Law School, where I've been teaching for 21 years. And I don't know of an event we have like this there, and so I think it's a lovely event, and I commend you for it. I've spent a good deal of time over the last 8-10 years working on issues relating to the role of forensic science. Oh, here's where I put up my first slide, right? Click the right. Oh, blah, blah, click the right. I'll get it. By the end, by the last slide, I'm going to be nailing this, I promise you. And I did it, obviously, as a lawyer when I was teaching and lawyering the Michigan Innocence Clinic at the law school, and I was sort of working my way through issues around forensic science representing clients in the courts of the state and the federal courts as well, including in the court I now lead. And then, since then, as a judge, I've had occasion to look at some of those same issues from the other side of the courtroom, which has been interesting when they get to me in a form that allows me to look at them, which is often a problem. And the combination of those experiences has given me a little bit more time to reflect on this particular topic more substantively than I do in my general jurisdiction job. I feel like mostly a firefighter. I mostly just am putting out whatever fire is happening from day to day. And I said to my husband the other day, who also was on the law faculty for a long time and also left for public service, left his full-time law faculty job. I said, I'm just a total generalist now. I don't know a lot about anything anymore. It's terrible. I've become, but this is like one topic that I continue to try and think about, both from where I officially sit, write about, lucky for me with Jules a number of times, and ETL. Now, as Chief Justice, think about the ways in which training or other education, both for lawyers and judges, might make a difference. So I appreciate the opportunity to talk a little bit about it, this topic with you today. And here we go. I hope today to interest you in two ideas. One, the potential I see in forensic science reform for our criminal justice system generally. And then, secondly, the role that lawyers are going to have to play to make that potential real. Picture this: a middle-aged man kneeling at a grave, tears streaming down his cheeks, his forehead leaning against the cold stone. The man's lawyers stand some distance behind him, uncomfortable, not knowing what to say or do for their client who had just walked out of prison after more than a quarter of a century. For the first time in 27 years, he was visiting the grave of his wife and 2 baby daughters. Finally, the man stands up. He embraces his lawyers. I was one of them. David Gavitt was standing at the grave of his family on that day in June of 2012, having been sentenced in 1986 to life in prison without a chance for parole. He was convicted of arson and murder, specifically using gasoline to burn down his own house and kill his entire family. The University of Michigan's Innocence Clinic, of which I was then the faculty member running it with a colleague, took on Mr. Gavitt's case in 2010 to look into it. A fresh look at the forensic science revealed that, in fact, there had been no gasoline, there was no arson, there was no murder. What had happened, we now know, was instead a terrible accident on a frigid March night. And when I say we now know, I mean that we now understand from scientific evidence that no arson started the fire that took Mr. Gavitt's family's lives. The prosecution's expert agreed. Mr. Gavitt spent 27 years in prison, having lost his family because the criminal justice system failed him. And I would say it failed all of us. Mr. Gavitt's story would be heartbreaking if it was only one of its kind. But it's not. It's one of many instances of indisputably wrongful convictions, wrongful arson convictions, that reflect an ongoing challenge in fire science and in forensic science more generally. The story of fire science has been told to a national audience, a national lay audience, in fact, in recent years due to some high-profile exonerations in arson convictions. Most famously, well, this one, let me take back the exoneration part for now. High-profile convictions in arson cases thought to be wrongful. Most famously, that of Cameron, oops, it's advancing without me even meaning for it to. I need like a technical, I'm sorry. I just wanted it like, well, it's fine for now. It'll still go forward. It'll work. So the Cameron Willingham case is one you might all be familiar with. He was executed in 2004 in Texas for a family home fire that happened in 1991. Some of you probably heard that story. And from it, you might know a little bit about the evolution of fire science. But let me try and summarize that briefly. John Lentini, a certified fire investigator, captures this evolution better than anyone in his book, Scientific Protocols in Fire Investigation. You've probably all read it, I know. Okay, no. He explains how advances in the science of fire and the investigation of fire were not coextensive, but rather surprisingly ran separate courses. Scientists' understanding of how fire behaves started to dramatically change in the 1980s, due in large part to technical advances that allowed the modeling and the measurement of fire's components components such as fluid dynamics, heat transfer, mass loss, and chemistry. But fire investigation procedures were not updated as the science advanced, at least not immediately. This is how fire investigators traditionally worked a scene. If they could see certain things at that scene, for example, what they thought were pore patterns on the floor or what they deemed an excessive amount of low burning, they'd conclude that the fire was intentionally set. Other markers included the melting of aluminum. It was thought that the fire could not get hot enough unless it was intentionally set with gasoline to be able to do that. Crazing of glass, that's an actual word, was thought to indicate rapid heating. We now know it comes from rapid cooling from water. And alligatoring, that's a term for the shiny blisters that develop on burning wood. The greatest advancement in the scientific understanding of fire happened in 1984 for one reason. The National Fire Protection Association, the NFPA, produced and released Countdown to Disaster, a 16-minute video of a test fire that was set to an everyday living room chair to mimic the behavior of an ordinary residential fire. For the first time, as a result of this experiment, it was understood that compartment fires behaved in the manner that was not before comprehensible to anyone who did not witness one. This experiment made plain what happened when there was a flashover event in a compartment fire. And it single-handedly dismantled the traditional assumption fire investigators brought to their work in determining a fire's origin. You're about to see, if my slides work, a condensed version of that video in a modified medium. A colleague emailed it to me as a WMV file. I stuck it into this PowerPoint and emailed it here. It's hard to remember in 1984 how much more complicated it was to see digital information. Let's see if this works. 1984.
This chair is stuffed with plastic foam. It has the fuel potential of 50,000 candles and no mechanism to control the release. The steady heat of a cigarette accidentally dropped between the cushions can create a disaster. Initially, the burning cigarette creates a smoldering fire, which breaks down the foam stuffing into vaporous fuel. When there's enough heat and oxygen, it starts to flame. More heat produces more fuel, and the fire accelerates rapidly. Smoke and other products of the fire, including unburned fuel, collect beneath the ceiling. Within 3 minutes, the temperature of the ceiling reaches 1,000 degrees, heating the contents of the entire room near the point of ignition. The carpet and other furnishings start to break down into vaporous fuels. Then, within seconds, in a process called flashover, everything in the room erupts into flame. No life survives flashover. After all the oxygen in the room is consumed, a pulsing backdraft sucks in air from the outside, depletes it in a surge of burning, then breathes in more. All this took place in less than 4 minutes and started with a smoldering cigarette.
Right? 4 minutes. Oops. Just saying, I'm not in charge of it. I'm not good at PowerPoint. Remind me not to do PowerPoint if you ever invite me back. But you had to see that video, so here we go. So as you saw, there is this transition phase in a compartment fire when the multiple surfaces that have all been exposed to thermal radiation reach the ignition temperature all at about the same time. And the fire just takes over the entire room, almost instantaneously. The experts characterize this as a moment when a fire in a room becomes the room in fire. As a direct result of this video, NFPA's Standards Council formed a technical committee on fire investigations. 7 years later, the committee released the first edition of NFPA 921, a guide for fire and explosion investigations, which is now the industry standard for fire investigation. It's impossible to overstate the ways in which NFPA 921 changed fire investigation, and most of those changes resulted from this new understanding of flashover. Once flashover was understood as a possibility in every compartment fire, fire scientists had to take a step back. They had to re-examine the physical evidence, which was previously thought to occur only in arson fires. As it happens, the physical evidence investigators previously considered unique to arson fires, low burning, melted aluminum, crazing of glass alligatoring, those things I talked about before, they were also present in innocent fires that reached flashover. Any flashover fire had those same components. With this new recognition that the same physical markers are present in arson and accidental compartment fires, investigators now needed to search for further to determine whether a fire was intentionally set, and to consider many of the same factors that they use in examining other crimes: motive and opportunity, means, context, detective work. Arson investigation had to evolve to align with good police investigation, and the fire investigation profession matured as knowledge of NFPA 921 and its requirements became understood throughout the field. But 1992 was not the year that fire investigation became reliable. In fact, there was resistance, some of it quite significant, in the fire investigation community. There was a write-in campaign to urge the NFPA to take out any reference to the word science in the 921 publication. The International Association of Arson Investigators filed an amicus brief in a federal case arguing that the cause and origin investigations were not scientific enough to be governed by Daubert. Yes, you heard that right. There's no science in our science, so we shouldn't have to be governed by the standard to determine if there's enough science in our science, right? There you go. And the brief asked the court to grandfather in the so-called traditional methods. But most of these growing pains were happening within the technical community of fire scientists and investigators. That changed in 2004 when Cameron Todd Willingham was executed in Texas for a house fire that killed his 3 young daughters. Willingham always maintained his innocence, and fire investigation experts expressed deep skepticism about the evidence that convicted him before he was executed. And in the years following his execution, investigative media cast even more doubt on his conviction. A second scientific shift in fire investigation occurred with the reassessment of the reliability of accelerant detecting dogs. I'm not going to walk you through the science on accelerant detecting dogs because I suspect I don't need to, but suffice it to say, it happened after the evolution of the understanding of flashover. Canine evidence was not mentioned at all in the 1992 or 1995 editions of NFPA 921, and accelerant dogs were still regularly used in arson investigations and prosecutions at that time. Instead, as the 1995 edition of NFPA 921 went to print, the official position of the relative scientific community was what it had been for a decade or more. Trained dogs have the psychic ability to detect accelerants at fire scenes, even where lab testing does not support the dog detections. Science caught up, of course. Sure, dogs can detect smells, we know that. But a dog cannot detect an accelerant when the lab says there was no accelerant there. We don't trust the psychic dog over the lab testing. That's good news, right? 2 steps forward? Maybe? But believe it or not, there was also resistance to the emerging scientific consensus about flashover. Just as there was resistance to flashover, there was also resistance to the repudiation of fire dogs, when the scientific community had rejected the notion that dogs had the innate ability to detect accelerants. The Canine Handlers Association held out until 2012. Took that long. The revolution in fire investigation has had important investigative consequences, as you might imagine. Oh, there's the dogs. As you can see from these slides from Massachusetts, the percentage of fires that were determined to be arson fires decreased from around 20% in 1984 to 2% in 2009. Back to David Gavitt, where I started. On March 9th, 1985, David Gavitt and his wife put their baby daughters to bed and were watching TV in their living room. They were both smokers. More people were in 1985, I promise. And they had those, do you remember these ashtrays that stood up on next to your couch? They had 2 of those ashtrays that stood on their own stands, standing ashtrays. They also had 5 or 6 kerosene lamps and many candles. They liked kerosene lamps and candles. And they had a big dog. They went to bed, and an hour later, they were awakened when their dog was scratching at their bedroom door. When they opened the door, they saw smoke. David pulled on a pair of jeans and headed to the living room where the smoke was present. He sent his wife to the girl's bedroom. By the time he got through the living room to the kitchen, the fire had grown exponentially. The fire in the room became the room in fire. And he had to try and crawl back through it to get to his family. He could not make it and broke a window in the back bedroom to get out of the house. According to the neighbors, who called the fire department, David ran around the house in his bare feet, bleeding and burned, trying to get back into his kids' room from the outside of the house. They reported having to restrain him from going back into the house because they knew he would die if he did. He was badly cut, badly burned. He suffered burns all over his body, and his wife and daughters died of carbon monoxide poisoning. Investigators said that the fire's physical evidence was consistent with arson, and further, that they conducted gas chromatography testing on 17 samples of things collected in the house, and that 2 of them tested positive for gasoline. When David Gavitt was released from the hospital some weeks later and taken immediately to jail, he was charged with the murder of his family and the arson of his home. He always maintained his innocence. He also always believed that someone set his home on fire because the investigators' findings said so. He spent 27 years trying to figure out who did. When he wrote to the Innocence Clinic, he wanted us to help him figure out who set his house on fire. In 2010, when the Innocence Clinic took a look at his case, we asked the Michigan State Police for the chromatography testing used in his trial in 1986. And to their great credit, they still had it, and they gave it to us. One of my students at the time, a law student, was a chemistry major in undergrad and was sure that the chromatography was misread. I will say that the prosecution's expert in the trial, and the chromatography expert, was a food science professor at a community college. So Chad might have been onto something, we thought. So we sent the results to an expert who said that, in fact, the chromatography had been misread. There was no evidence whatsoever of gasoline or any other accelerant in any of the samples. The prosecution sent the testing off to their own experts, who also agreed. There was no question. The rest of the evidence was therefore the investigator's description of what used to be thought of as signs of an intentional fire and were now known to be consistent with flashover. The newly elected prosecutor in the county where this case was tried, to his great credit, agreed to David Gavitt's immediate release and dismissal of the charges. When we picked him up from the prison, we thought he might want to get some food. I've picked up a number of people who've spent a long time in prison, and they're usually eager to get some food. We were wrong. He wanted to go directly to the cemetery. Fire investigation is not the only forensic discipline with a spotty relationship to science. And I promise I'm not going to go discipline by discipline, but permit me a brief detour through forensic odontology, or bite mark evidence. Sorry, Jules and Marissa, you can leave because you know all this, but not everybody else does. In 1994, Monica Reyes went missing, and 5 days later, her body was found in a ditch, covered in half an inch of snow, with heavy rocks on her head and feet. She had been beaten, strangled, and stabbed. 28-year-old Gerard Richardson was charged with and convicted of her murder and sentenced to 30 years in prison. When he was sentenced, his oldest child was 12 years old. His youngest was not yet born. Bite mark evidence was the key to his conviction. No other physical evidence tied Richardson to this crime. The prosecutor's bite mark expert confidently told jurors that there was no question in his mind that Richardson bit the deceased on her lower back. And he could tell that from an examination of Richardson's teeth and the bite mark on the body. Notwithstanding all of the trauma to her body and the prolonged weather exposure, the expert's analysis was recorded in one page and simply identified Richardson as the culprit. Richardson later recalled to a Washington Post reporter, "There were only two things on that sheet. It said there was a bite mark on the victim and that I had made it." I suspect this was not the threshold that the Supreme Court of the United States had in mind when it established the Daubert test 2 years earlier in 1993. And not that this information made its way to the judge or the jury, but the prosecution's experts' courtroom confidence was unsupported by the only then existing scientific study from 1975, where analysts were tasked with matching bite mark impressions from 24 different adults made in non-vital pig skin. I know you were going to want to know if they bit the live pigs, so I added that detail. In that study, there was a 24% error rate in matching fresh marks in the pig skin and a 90% error rate in matching the photos of the marks taken 24 hours later. I don't mean to be unnecessarily critical of the lawyer who didn't get that information to the judge or the jury. Context matters, and some of us in this room are old enough to remember that in 1995, Westlaw, Lexis, and the internet were not at our fingertips, as they are today. 1995 research required a well-inventoried library, microfiche, card files. Some people don't even know what this is. Dimes, lots of dimes. Remember, we had to have pockets of dimes to go find stuff? It was fun, but not as efficient. Back to Richardson's November 1995 trial. When questioned about his methodology and why he was able to single out Richardson as the biter, the prosecution's expert said that he relied on a more detailed report offered by the defendant's own bite mark analyst, but the defendant's expert told the jurors that there was no way the bite mark could have been left by Gerard Richardson. In other words, the two experts relied on the same report and came to opposite conclusions with complete confidence. Excuse me. Gerard Richardson's conviction was overturned 18 years later, but only because DNA testing cleared him. That testing on the bite mark swab produced a complete profile which excluded Richardson. He was also excluded from the deceased's vaginal swab sticks, genital gauze swabbing, and fingernail clipping. He served 18 years. Bite mark evidence has undergone its own scientific evolution, or maybe evolution isn't the right word exactly, as it's difficult to identify any moment where there was any scientific support for it. But in any event, the scientific discrediting of bite mark evidence has been met with resistance from the bite mark analysts in a similar way the arson investigators resisted NFPA 921. As I said, the scientific critique of bite mark evidence is not new. At least since 1996, Michael Bowers, who's a practicing dentist with a law degree, who consults as a forensic odontologist for the Ventura County Medical Examiner's Office and is on the faculty at USC, and he's known as the dental detective, which is awesome. That's my next job. I want to be a dental detective. He's been sharply critical of bite mark matching. According to Bowers, physical matching of bite marks is a non-science which was developed with little testing and no published error rate. In 1999, Bowers conducted a study he's now famous for at an American Academy of Forensic Sciences conference. He invited conference participants, people attending the bite mark analysts, to match bite marks with the teeth that made them. The experts misidentified more than 60% of the samples. Bowers published the results, and this did not go over well with the analysts. 2 weeks after Bowers published his book, Forensic Testimony, Science, Law, and Expert Evidence, and 1 month after Gerard Richardson was exonerated, the president of the American Board of Forensic Odontology filed a 6-page complaint against Bowers with the American Academy of Forensic Sciences Ethics Committee. It alleged 13 ethical violations over the course of 13 years And the complaint was filed just as Bowers was preparing to testify as an expert in 2 lawsuits against bite mark analysts brought by the exonerees who had been convicted by their testimony. The complaint was eventually dismissed by the full board, but the outcome was far from certain. It was a prolonged affair, and the vote was against the recommendation of the Ethics Committee. Incidentally, Jennerin Block represented Mr. Bowers pro bono in that matter. And Bowers is not alone in being targeted for his insistence on scientific rigor in this field. Mary and Peter Bush lead a team of researchers at SUNY Buffalo and have tackled the question of scientific validity of bite mark evidence. They knew that they needed to understand if human detection is unique and if human skin can preserve bite marks in a way that allows for matching. They used dental molds and human cadavers. Since previous tests used only animal skins, this was new and important research. They found no scientific basis for any claim that human dentition is unique. There was also no evidence that human skin is capable of recording and preserving bite marks in a useful way for matching. The results from their testing allowed for only one conclusion. Bite mark matching is a completely subjective enterprise. The first of their approximately 12 articles was published in the January 2009 issue of the Journal of Forensic Sciences. The pushback against them was also not subtle. 3 times, a handful of bite mark specialists penned a letter to the editor of the Journal of Forensic Science to harshly criticize the Bushes. The first 2 letters were rejected for their improper tone, and a tamed version was eventually published. In 2013, a month before Gerard Richardson would be exonerated by DNA testing, the prosecution expert who testified about the so-called bite match in his case attended a panel discussion on forensics hosted by the American Bar Association. Mary and Peter Bush were also on that panel, and he made it a point to deliver strong criticism of their work during the Q&A. And at a 2014 American Academy of Forensic Sciences conference, an assistant district attorney from Manhattan delivered remarks which were described as a direct and personal attack on Mary Bush. The assistant even used the forum to attack Mary Bush's physical appearance, and it wasn't the only time this same assistant took on the Bushes. For their part, the Bushes were mostly stunned. Mary Bush said, "We were naive going into it all. We thought we were providing research that would help prevent innocent people from getting convicted. We expected disagreement, but we expected polite academic disagreement. We never expected the response to be so vitriolic." Incidentally, when the Bushes testify, they do so pro bono. They don't accept fees. They also don't address the bite mark evidence in any given case. They simply present their research. No one knows who killed Monica Reyes. The Innocence Project had a full DNA profile done, but the DNA was tested in a private lab in California, and FBI regulations prohibit tests from non-state labs from entering their national database, the Combined DNA Index System, unless the lab is pre-approved. There are over 10 million DNA profiles in CODIS. A match could provide closure and justice for her family. There's more. Ask Jules or Marissa later about comparative bullet lead analysis and the FBI's response to the conclusion that there was no scientific basis for that evidence, and then ask them about ear print matching. Yep, ear print matching. Footprint matching, blood spatter, I could go on and on and on, but I'm not going to. I want to take a step back from the particular disciplines now and talk about the NAS report. Nearly 15 years ago, the National Academy of Sciences was charged with creating a forensic science committee to assess resource needs, identify new technologies, disseminate best practices, and make recommendations to maximize the use of forensic technologies to solve crimes and increase the number of qualified forensic scientists and medical examiners available to work in public laboratories. DC Circuit Judge Harry Edwards chaired the committee. The NAS's 2009 report was a bombshell. I understand that in 2009, 10 years ago, this lecturer, Barry Scheck, was the one who gave it about this report. And I further understand that he showed up real excited because he was sure that this was going to change everything. And here I am. While the committee hailed some advances in technology, especially regarding the use of DNA that have aided in solving crimes, it also raised a very serious alarm. In particular, the committee cited disparities in forensic science resources across jurisdictions, the lack of mandatory standardization, certification, and accreditation in the field, and the disturbing fact that within specific forensic disciplines, there are often no standard protocols or governing practices at all. Not surprisingly, bite mark evidence was prominently featured in the report. Most courts, it turned out, were not subjecting bite mark evidence to Daubert evaluation at all. Again, not enough science for the science test. The NAS report confirmed that there was no scientific research or basis for saying that the impressions our teeth make is unique to us in some way that our fingerprints or DNA are. And due to the elasticity of human skin, the swelling and healing processes, and the unevenness of the skin's surface, the marks made from a bite can morph over time. The Academy was even more skeptical of the analysis done from photographs of bite marks, given that the photographs allow for further distortion of the marks. Finally, the committee emphasized the serious problems relating to the interpretation of forensic evidence across disciplines. According to the Academy, with the exception of nuclear DNA analysis, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. To address these problems, the committee made a set of ambitious recommendations. Among them, it recommended that Congress establish and fund a National Institute of Forensic Science, an independent federal entity that would promote the development of forensic science into a more mature field of data-driven, multidisciplinary research. The new institute would establish and enforce best practices, establish standards for accreditation, and promote and fund peer-reviewed research that would develop new technologies and improve the understanding of forensic science disciplines and their limitations within the legal system. As I said, there was a lot of excitement in 2009 that the report would really bring fundamental change to the criminal justice system. Congress never got to establishing that institute, but President Obama took a swing, creating the National Committee on Forensic Science as a partnership between the Department of Justice and the National Institute of Science and Technology, which is an agency within the Department of Commerce. And President Obama did that in 2013. NIST is the agency that, among other things, standardizes weights and measures. Historically, this standardization produced and promoted commerce, as buyers and sellers needed common units to trade. It is NIST who made sure that a gallon is a gallon. In other words, NIST is a completely apolitical technical body. They were already doing some work in their labs on forensic disciplines. And the point of partnering NIST with DOJ was to bring scientific precision to the methods and techniques of criminal adjudication. It was an exciting partnership. The commission included federal, state, and forensic science service providers, research scientists and academics, including Jules, law enforcement officials, prosecutors, defense attorneys, and judges, including me. And we worked somewhat furiously for 3 years to ensure that good science serves justice. And in that time, we produced 43 work products, 20 recommendations, and 23 views documents, many of which the Attorney General adopted. And it was significant work. Just for a couple of examples, we recommended that universal accreditation for forensic science providers, and the Attorney General promptly required that of DOJ-run labs. We recommended that the Attorney General direct these same labs to adopt root cause analysis protocols and to establish policy procedures to address mistakes. The AG required those steps of all DOJ labs in March of 2016. I could go on, and I won't, but 2 steps forward, right? Felt like it while we were doing it. But there was a lot more work to do when the new Attorney General in 2017 declined to renew the commission's charter. The Attorney General announced that they would move the effort to improve forensic science in-house at DOJ. You can still find the work product archived on the DOJ website, but it has a big warning flag that says you can't count on it. One step back, maybe. The commission was a mix of scientists and legal professionals because while the scientific community has ownership over the advances in the specific scientific disciplines, it's the legal community that has to determine how to manage those disciplines in our processes which are often life and death. The overlap is significant, of course, but it's not perfect. And despite some of the interdisciplinary struggles within the scientific community, they can make progress with or without us, and we can make progress with or without them. That is to say, science doesn't need lawyers to demand that it improve, and law doesn't need scientists to demand what is acceptable in our courtrooms. And the National Institute for Science and Technology has actually continued to work on these disciplines. At the NIST campus, there are labs actively conducting research in several forensic disciplines, including DNA, ballistics, fingerprint analysis. They also administer the Organization of Scientific Area Committees, which is charged with facilitating the development of science-based standards and guidelines for forensic disciplines. The OSACs, as they're called, are not immune from the resistance I described in the fire investigation and forensic odontology communities, at least so I hear. I understand Jules is serving on one of the OSAC subcommittees. That gave me hope. 1 step forward, 2 steps forward? 2, let's call it 2. But I was disheartened to learn that another colleague of mine, my co-director of the University of Michigan Innocence Clinic, recently decided not to re-up on his OSACs committee because he was frustrated by the lack of forward progress there. 1 step back. Some individual labs have also taken the initiative to improve their own work product, sometimes as a result of public exposure of massive failures. Some of you may have heard about the massive lab failures in recent years in Boston, Detroit, New York, Houston, Minneapolis, Colorado Springs, and a number of others that have focused attention on the need for improvements within those labs. But there are also labs and lab directors who are leading in bringing best practices to their labs without anyone requiring them to do so. Without any court order or consent decree, some labs and lab directors are requiring that their practitioners be certified, that their labs be accredited. They're building quality assurance units into their lab's structure and incorporating blinding and other processes to avoid the effects of cognitive bias. They are meeting with defense attorneys. Some, like the Houston Crime Lab, are even independent of law enforcement. But we control our courtrooms. We don't have to wait for the scientists to decide what evidence meets the standards we have set for our own processes, which brings me to the lawyers. It's the lawyers and the judges who decide what science we can rely on in pursuit of justice. But it's lawyers even more than judges. Judges' decisions are only as good as the questions that lawyers ask us to decide. Except I learned in Pennsylvania, where you have this thing called the King's something bench writ something, which I had never heard of. And apparently in Pennsylvania, judges can fix everything, so lucky you. But in most of the country, judges answer questions that lawyers ask us. Lawyers have been leaders in important reforms in our justice system throughout history. The centrality of procedural due process, for example, so basic in our legal system today, was ushered in through a series of cases like Goldberg v. Kelly. As you will recall, in Goldberg, the Supreme Court held that the Due Process Clause requires that before a recipient of government benefits can be deprived of those benefits, she's entitled to an evidentiary hearing. And so now due process likewise protects any legal entitlement. And structural reforms of our criminal justice system that we consider so basic today were the result of lawyers' work in cases like Gideon versus Wainwright. And of course, the NAACP lawyers, whose victory we now know as Brown versus Board of Ed, where again, litigation brought by lawyers on behalf of individual clients, though with a larger vision of the social good, brought our legal system and its rule of law closer to the ideals of basic justice. We need lawyers thinking about litigating forensic science reform in our courtrooms in big picture ways. The legal system needs its forensic Goldberg, its forensic Brown. But our trial court lawyers have to be insisting, in our trial courts, lawyers have to be insisting on Daubert hearings, no matter how accustomed courts are to admitting particular evidence. On appeal and in post-conviction proceedings, when a forensic practice is revealed to have been without scientific foundation, lawyers must litigate those claims as new evidence claims or ineffective assistance of claims, depending on the timing of the junk science determination. And sometimes neither will work. I know you all know this. There are far too many appellate cases where a litigant has framed a junk science issue as new evidence and has been told that the problems with the evidence were not really new after all. And when that same litigant then said, well, then my lawyer was ineffective for not bringing them to the attention of the jury, the court has said, no, her practice did not really fall below the standard of care. But we have to keep working on it. And perhaps there's a third claim, a due process claim. This claim might find its footing in Chambers versus Mississippi, where the court held that trial procedures that apply mechanistically to defeat the ends of justice violated due process. In a Sixth Circuit case, the court applied the Chambers principle to bite mark evidence, which the petitioner claimed was both substantively and probabilistically unsound. This is how the testimony went. Question, now doctor, with regard to your testimony, you indicated that it's highly consistent with the dentition of defendant Carol Ege, is that correct? Answer, yes. Question, okay, with regard to, let me ask you a question. Let's say you have the Detroit metropolitan area, 3.5 million people. Would anybody else within that kind of number match like she did? Answer, no. In my expert opinion, nobody else would match up. The court, the Sixth Circuit, held that the testimony was completely divorced from any scientific foundation at all and therefore violated the petitioner's due process rights. All of these litigation strategies might be effective in the individual case. That's the thing about appellate review. We may be able to fix the problem that went wrong in this case. I say may because there will often be preservation or other procedural hurdles that prove fatal, finality versus accuracy and all that. But that's often the extent of the fix. So what I also want to encourage lawyers to do, and those of you teaching young lawyers to do, is to get smart on forensic science, not only in their individual cases, in their trials and in their appeals, but also to push the judges to make hard decisions, and then to think about ways in which they can affect the whole system. We need Goldberg lawyers. We need Gideon lawyers. Litigation in the individual case remediates a past error, but it doesn't necessarily prevent a future one, though it can. Given that, shouldn't we also be talking about how systems can become self-educating and what self-educating criminal justice might look like? Think about how other systems where errors can be devastating approach that error. Medicine and aviation, to name two. Each has a long history of error management, aviation perhaps more sophisticated even than medicine. And imagine if we thought of the criminal justice system like any other regulatory system, such that we might be able to improve it by employing the best error management strategies. Incidentally, the rate of wrongful conviction, experts put somewhere between 3 and 5%. And if you thought of wrongful conviction, or if you think of the criminal justice system kind of like shooting free throws, you're probably doing pretty well if you miss 3 to 5% of the time. But if you think of it like landing planes, not great, right? So if we were to approach our criminal justice system like we approach aviation, we would start with an honest assessment of our system and what ails it. We could then work on error prevention, figuring out which design-based systems could help us avoid errors entirely. We could separate and focus on error reduction, putting in place protocols that minimize both the likelihood and the magnitude of error. And we could target error detection so that errors would be plain to see as clearly as possible. And we could work on error recovery and tolerance. We would engage in root cause analyses of errors when they occurred, and we could understand what caused them and systematically respond to them. We would build in structural checks and balances for confirmation bias and motivational bias. There is a sophisticated literature and tested protocols and techniques for this kind of risk management. Systems approaches to error in our forensic labs and in our courtrooms, reliance on the work done in those labs should appeal to every stakeholder. Building a more efficient and more effective and more accurate criminal justice system means better outcomes, which in turn increases public confidence in the rule of law. Lawyers have to be leaders in systemic reform. Bar associations can tackle system-wide problems and recommend reforms that change a practice. They can insist on training lawyers in forensic fundamentals, and courts can do the same with judges. They can advocate for statutes and court rules which permit challenging junk science after the fact. In 2013, the Texas legislature passed a law commonly known as the junk science writ. It was the first of its kind. And it permits a defendant to bring a habeas corpus writ on the basis of new or changed scientific evidence. In practical terms, it means that courts must grant relief in cases where new scientific evidence has come to light, or where the scientific evidence used to convict has been shown to be false, misleading, or otherwise inaccurately applied. And just last fall, the Michigan Supreme Court added specific language to our rule explicitly permitting a successive motion for relief from judgment, a state habeas motion, to include scientific shifts in scientific consensus, methods, knowledge, or opinions. That change was proposed by lawyers who wanted to see change beyond their individual cases. 24 years ago, Tony Kronman, the then dean of the Yale Law School, published this book, The Lost Lawyer. We all read it in 1995. Everybody read it. And it articulated a view of the lawyer statesman, as Kronman called it. It was a view which Kronman regrettably found historic, he argued, by 1995. Kronman's critique went like this. Lawyers were, at one time, something more than an expert in some area of the law. Their expertise was more so in judgment than in any specific legal subject matter. And it was their judgment, the product of practical knowledge beyond legal knowledge, which their clients valued. The lawyer statesman, as Kronman described him, used her judgment for the greater good. She was selfless, committed to civic virtue, empathetic, and also persuasive. Moreover, the profession itself was committed to developing lawyer statesmen. By 1995, Kronman believed that it was plain to see that the law firms, the law schools, and the courts believed the profession was in decline. The lawyer statesman, he said, was hard to find. There were lots of thoughtful critiques of Kronman's perspective in the years since it was published, as well as lots of contemporary conversations about whether his gloomy prognostications have proven true. Since 1995, some say that a lot of what Kronman thought ailed the profession has calcified, but I am not one of them. I live in a legal marketplace where a whole lot of lawyers are not working in big law. They're working in government or public interest organizations or smaller firms or very many in solo practice. The University of Michigan Law School sends many graduates to big law, but the other law schools in my state send a lot of people into solo practice. And in many cases, they are serving as lawyer statesmen to their clients. At least that's what I see. Maybe the economic model in big law has made the relationships that define the lawyer statesman and his clients harder to achieve, but there is a whole lot more room for that in these other practice models. And I see examples of it in the world I am living in. You have some here. Your local district attorney, Larry Krasner, I don't know him, is certainly one example. His approach to pretrial detention and now to probation and parole supervision can have, if it works, profound effects on the community and the criminal justice system. And it has inspired others to take on a similar role in cities across the country. We have candidates running for prosecutor on his model in 3 big counties in Michigan right now. In Detroit, Michigan, the Detroit Justice Center is using a 3-pronged approach, what they call defense, offense, and dreaming, to serve individual clients, build economic opportunity, and engage stakeholders in systemic solutions, all in one law shop. They are promoting restorative justice practices and working with the city and state government to turn prisons and jails into community centers. They're representing people in eviction cases and negotiating with the mayor to take a closed-down jail and make it a community center. They're lawyer statesmen. And I'm not even sure I buy the view that the lawyer statesman can't be found in big law anymore, even if the market has changed the nature of the way they do some business, such that they sometimes find themselves pulled in more directions than their statesman side prefers. The student who first read the chromatography in the Gavitt case is a partner at Jenner & Block. He's a patent lawyer. I assume that means he bills a lot of hours. And he is a regular partner with the Michigan Innocence Clinic in its appellate litigation. He brings together unique communities in amicus filings. I've seen his work in my court, and it is the work of a lawyer statesman. The practice of law has certainly changed, and it will never again be what it was in 1963. But of course, the world isn't the same, nor are the problems, and nor are the potential solutions. We need lawyer statesmen in forensic science reform in our courtrooms and in our systems management. Courts, judges, are small c conservative. We're restrained. We don't act on our own initiative. We don't reach issues not before us. But when lawyers bring us hard questions, we will answer them. Our courts are only as good as the lawyers who inhabit them. We, you the lawyers, the judges you appear before, and the judges as well, control our courtrooms and our justice. We can insist on reliability and standardization and science in our forensic science if we are going to permit it to serve justice. And when we do, that's what we'll get. At the very first meeting of the National Commission on Forensic Science, Judge Harry Edwards joined us and addressed us, passing the torch from the National Academy of Sciences to the Commission. He ended his speech with this. In his 1963 letter from the Birmingham jail, Reverend Martin Luther King Jr. reminded us that injustice everywhere is a threat to justice everywhere. Isn't that the point? We're not talking about good science merely for its own sake. We're talking about the need for good science in order to serve justice. And when justice is done, our society as a whole is better for it. The stakes are high. And I believe that in the long term, it is the lawyers who will push us to ensure that the integrity of the system they serve holds up. Justice demands it, and they will demand justice. Thank you very much for having me. I appreciate it. I'm fine, yeah.
So forgive me again, but we have time for a couple of questions. Anyone in the audience? All right, so I'm going to start here, and then we'll pass the microphone back. Please go ahead.
Thank you so much for coming. It's fabulous to hear you speak again. I'm a student at University of Pennsylvania Law School, and I'm working with the Innocence Project's clinic here at Temple. I have a question for you about something that you brought up, which is the dichotomy between finality and accuracy. I'm curious as if your perspective on this have kind of changed since you've been on the bench, especially considering sort of the narrowing window within which the new evidence can come in a collateral proceeding.
Yeah, it's a great question. I mean, it's obviously like it's a question for all time, that the balance between finality and accuracy and how it's thought through in the given case. And I'm lucky to preside in a state where we have a generous post-conviction process. So new claims of innocence almost always are able to see the light of day. If not in the original trial court, they do get reviewed eventually in the appellate courts. But that's not the case everywhere, and obviously states have the ability to establish post-conviction procedures that favor finality over accuracy, and the constitutional line there is pretty low. I feel grateful that I happen to serve in a state that allows those claims to actually be brought to our attention, because, the overall, the rules of the preservation and, judges answering questions that lawyers ask and not others, I think we want our courts to stay in their lane and do business that way. So it's nice to be able to be in your lane and still answer the accuracy question.
I had two questions. One, several years ago, the Scientific News, New Scientist, ran a multi-volume article on the subjectivity in certain kinds of composite DNA analysis, and that it wasn't the gold standard we assumed. And if you could comment on that, if you're familiar with it. And secondly, has there been any attempt to subject fingerprint analysis and fingerprint conclusions to some kind of national standardization and to subject it to Daubert before it can come in?
Yeah, I mean, Jules and Marissa will probably answer you better on each of those two disciplines, but DNA changes, monthly, weekly. The DNA technology changes all the time, and the newer techniques, as each of them is introduced, have had some hiccups. There have also been some DNA labs where it's been shown that there were some mistakes made or regularly being made across the lab. So it's not, I don't think, even though the science behind DNA, I think most would agree, is the gold standard, that's not to say that any particular lab that's running a DNA, is doing everything right. And so we still need really good lawyers testing it on both sides. I don't think DNA is ever going to be to the point where you can say, oh, here's a DNA answer, we don't need lawyers. So
the real quick answer on what's called DNA mixtures, which is where you have DNA from
more than one
multiple
person.
sources. Dr. Dror, who
Yeah.
Bridget talked about ETL drawer, and others have done some research, because the more DNA that's mixed up, the more interpretation there needs to be. And they have shown that if you give people what's called domain irrelevant information not about the DNA, but this guy confessed or whatever it is, that can color the judgment. And forgive me, and
Fingerprints,
as to
the
fingerprints,
the
real
latest
quick,
fingerprints.
that's the idea of these OSACs. So these organizations of scientific area committees are set up. So there is a latent prints OSAC, but it's not just populated by fingerprint folks. It's got researchers and engineers and people who, statisticians, thank you, Marissa, in particular, to try and do that. And I think fingerprint evidence is probably ahead of most of the pack on the subjective ones.
Yeah,
Right.
I think that's right.
So will you join me again, please, in thanking our speakers?